Hi, this is Brian Dolan with the law firm Pepper Hamilton. Pepper partner Greg Nowak hosts a monthly webinar for West LegalEdcenter. This month, Mr. Nowak was joined by Pepper attorneys Joseph Guagliardo, Todd Kornfeld, and Johanna Wood, and Director of Business Development at Trident Trust Group, David Madden. The panel discussed recent regulatory developments and trends in the marketplace, both from the point of view of the ICO crypto issuer and the ICO crypto investor. This podcast is a recording of that webinar. You can also download the PowerPoint slides from the session by visiting Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted.
Well, good afternoon. This is Greg Nowak. I'm a partner in the Financial Services Group at Pepper Hamilton. Welcome to our monthly edition of the Private Funds Roundtable. Today we're focusing on blockchain, cryptocurrencies, and ICOs. What's happening now? Those of you who are following the space know that the regulators, federal and state, have been extremely active, as well as international regulators. And so we are today faced with a very different landscape than we had just a few months ago when we did our first installment of blockchain, cryptocurrency, and ICOs. I'm joined today by a very distinguished group of attorneys and business persons. First, we have Dave Madden, who's the Business Development Director for hedge funds at Trident Trust. Tell us a little bit about Trident Trust, Dave.
Sure, Greg. Thank you. And hello, everybody. Trident Trust, we're a global boutique fund administrator. We've got $40 billion in assets under management with traditional base clients of the traditional hedge fund and private equity. We were one of the first administrators within the crypto sector, currently working with a number of clients now, with many more onboarding. I personally take a very consultant-like approach with my clients and prospects just to ensure they're able to navigate the service provider world.
Thank you, Dave. And also joining me, ladies first, Johanna Wood. Johanna is an associate in our Corporate and Securities Group and has been very helpful in putting the materials together for today's presentation. We'll be using Johanna as a resource to walk us through the cases and tell us what we need to worry about with respect to the recent enforcement actions that we've seen from the regulators. And joining me are Todd Kornfeld, not a stranger to these programs. Todd's of counsel in financial services at Pepper Hamilton and has been a frequent participant in the investment management roundtables. And then my partner, Joe Guagliardo, who's in our intellectual property and tech group. We often describe ourselves, Joe and I that is, as the two sides of FinTech, where he's the tech and I'm the fin. So, without further ado, we're going to get into our topic of the day. By the way, materials are presented, and they should be available on the Thomson Reuters website for the presentation. Our presentation overview, what's happening with Bitcoin and cryptocurrencies, and then the engine of Bitcoin and cryptocurrencies, blockchain, and then a further permutation, initial coin offerings. We're going to be talking about recent regulatory initiatives as well as other developments that we've seen in the marketplace. Turning to slide number 4, this is an example of why it's important for us to focus on this space. The volumes that we are seeing in the various cryptocurrencies and alternative coins has just exploded. Bitcoin now has a market cap of well over, if I'm reading that correctly, $171 billion, and that is an enormous increase. Circulating supply is roughly 16,866,000 Bitcoins, an increase of roughly 9.4%. The other cryptocurrencies out there have seen similar explosive growth, with Ethereum representing roughly 50% of the marketplace that Bitcoin has in terms of market capitalization. I'm going to ask my colleague, Joe Guagliardo, to just give us a quick snapshot. Joe, from the tech side, is tech driving this growth, or is this growth coming from just organic user acceptance of these various coins?
Yeah, so I think what's driving this is actually a combination of a bunch of different factors, including investment opportunities and speculative trading, as well as the tokens being used to enable a technology. So if you sort of look at blockchain and the cryptocurrency space, at the core of it is the technology, right? This is a new database technology. And so what companies are doing, and if you look at Bitcoin and Ethereum as sort of the baseline, these are tokens that enable these platforms. They're either used to access it, they're used as a medium of exchange or a store of value. But the tokens are, at the end of the day, they're enabling a technology. And I'm using the word enable very broadly. They're enabling in the sense that they're allowing, rightly or wrongly, and within the regulations or not, to raise capital to build platforms. They're being used as so-called utility tokens to actually fuel a network, right? So think of it as a license key or a software as a service key to get access to a platform to develop, an application on top of it. And they're being used, as I mentioned, as sort of a payment token to move a store of value from, one individual to another. So, at the end of the day, it is still technology, but what's driving it is a number of different factors: the growth of these platforms, speculative trading, and a number of other sort of influences that's helping them to grow this the investment opportunity.
So let's talk a little bit about the technical side of things. There was, at one point, some, putting the word difficulty in air quotes, in converting some of these coins to fiat currency. And it was serially represented to be the result of technological glitches, of depth in the marketplace, of the need to match buyers and sellers. What are we seeing now in terms of the liquidity of these large trading positions between fiat and the currencies themselves?
Yeah, so, the larger exchanges are, and actually all of the exchanges are basically market makers. And so there's, in order to get fiat currency, U.S. dollars, or any other kind of fiat currency into the market, you have to come in through some bank, right? And or some regulated entity that actually holds these funds. So getting the funds onto the exchanges like a Coinbase or other is really a matter of linking your account or credit card, and some of the credit card companies have actually shut that down. But so getting it on the exchange and then converting your fiat into a Bitcoin so that it can be traded into other types of tokens is really that's the gating issue. Getting it off the exchanges, getting fiat currency off the exchanges is a whole different matter. Some of it has to do with liquidity. These are market makers, and so just like a bank, you wouldn't be able to go into a bank and the local branch and say, I want to withdraw $1 million. They probably don't have it on hand. A lot of these exchanges have the same issue, right? If people are trying to pull all their fiat currency off the exchanges at the same time, there's liquidity. There's an issue with the funds being available.
So that's actually a very important point for our audience to remember. Those of you who are heavily into the space already know this. Those of you who are listening because you need CLE credit, well, God bless you. And those of you who are, listening because you're regulators or otherwise involved in considering either a product in the space or potentially making an investment in the space, liquidity is an issue.
Yeah. And
the movement of fiat currency into these coins and vice versa, you're using terms like market maker. Now, when I think of a market maker, again, remember I'm a securities lawyer, the first thing I think of is a registered broker-dealer.
Right.
Are these registered broker-dealers?
Yeah, so, you think about a market maker, yes. When we talk about market maker, you think, securities, right? Or FX markets, But I suppose you can have, so these exchanges assume that these tokens are these so-called utility tokens. But you can have a market maker for goods as well, right, for buying and selling goods. And so when I use the term market maker from a technology perspective, I'm using that in the broadest sense. And with respect to these so-called utility tokens, I'm using it in terms of they're a market maker for a product, right?
Now, one of the other...
The spot, this sort of commodity spot exchange versus some other type of exchange.
Todd?
There's some issues here, and just focusing on the U.S. There's no real federal regulation of somebody who's operating a marketplace for the spot exchange of crypto into cash, or from crypto to another crypto, Ether and into Bitcoin.
If they were, assuming that they're not securities.
Right, assuming they're not securities, right? We're taking that for a given. And we do know that, at least with respect to Bitcoin, we know the CFTC thinks Bitcoin is a commodity. We know the SEC seems to have acquiesced in that determination based on their public statements. There's no federal regulation law. It's a spot trade. If it's a leverage trade or a prime brokerage trade or involves an extension of credit or it's a future, then it probably requires CFTC regulation, registration of the...
Now, that's a very, very, very important point. Spot trades are not considered to be subject to CFTC regulation, even though the CFTC has concluded that Bitcoin is a commodity.
They are.
Where you have leverage or where you have a futures transaction or some other contracts that's squarely within the jurisdiction of the CFTC.
Well, there's a subtlety here. It depends on how you define jurisdiction. They do have jurisdiction over spot trades, but all they have is anti-fraud jurisdiction. There's no registration requirement. If somebody's doing leverage transactions,
so 10b-5 type,
exactly,
very spot trade,
right.
But a out and out spot trade of Bitcoin to Ethereum or vice versa is not going to be regulated by those federal agencies at the present time.
Right. So there's no registration requirements or anything like that. If somebody was operating an exchange and where they said they stole your money, or engaged in some other fraudulent activity, the CFTC probably would have the ability under the anti-fraud statute and rule it. It's 180.1 actually is the rule to go in and do some sort of enforcement activity.
What about shorts? What about a short against Bitcoin or a short against Ethereum? Because some of the markets will allow you to borrow the security and sell it into the marketplace like you would if it was
That's an interesting question because the short, in order to short, you have to be able to borrow the thing.
Right.
And when you borrow the thing, that may actually that's a financing transaction. And that may very well require a CFTC license. There are several exchanges that have taken the position that is not a CFTC regulated activity. And there are some, and the CFTC probably disagrees with that, but so far there haven't been any enforcement actions. So it's a wait and see sort of thing to mention. The other thing to mention is, we just were talking about federal. On a state level, there are a number of states that regulate these sorts of transactions, even in a spot market, either as a money transmitter, say the money transmitter license, or most well-known in New York, the New York BIT license, which is a rather difficult, not difficult license to get. You can get it, but it's burdensome to get it and almost requires you to be a bank in terms of type of AML and a type of information you have to give the state. And a number of exchanges pulled out of New York for that very reason. They didn't want to have to comply with the New York license requirements, although there are a number of exchanges that do.
All right, so let's turn the page, look at page 5. You can see in the regulatory update, we've touched on some of these topics. The CFTC does view cryptocurrencies as commodities. However, in a spot exchange, they have to this point said they do not have the authority to regulate that unless there's leverage or some other futures contract or derivative involved. Shorts, we have a divergence of opinion among the exchanges, whether or not that gives rise to the need for an exchange to be a futures commission merchant or some other form of board of exchange that the CFTC regulates. The SEC, on the other hand, and we're going to get into this in depth in a moment, has viewed some cryptocurrencies and tokens as securities, following the Howey test and the Revis test and a whole long line of Supreme Court and other cases that have attempted to define what is and is not a security, but has turned the cryptocurrency market into somewhat of a turmoil as the law firms and other gatekeepers sort through what all this means. The IRS believes that all virtual currencies are property. They've said so in notices, and they expect that if you exchange Bitcoin, where you have a dollar basis and a fair market value in dollars, therefore a differential, a gain, when you deliver that Bitcoin in exchange for other property, you have to recognize your inherent gain. And the statistics, however, seem to show that there are just not that many people reporting their cryptocurrency gains as taxable income. The result of which is the IRS has started its own enforcement actions, going after various exchanges with so-called John Doe summonses, asking for information about the participants on those exchanges. And when they get that information, then that's when they pursue people for material understatement of taxable income and other penalties that might be applicable. So you are forewarned that the IRS is probably going to get that information. It's very hard to defeat a John Doe summons, as I understand it. And when they get that information, they often share that information with the states. So you're not even looking at just an IRS issue. You're looking at potentially state income tax issues as well. And as Todd alluded to, various states have licensing regimes that may or may not be applicable. The key issues there are you an issuer or are you a transmitter? If you're the issuer of a coin, you may be able to avoid some of this regulation, just as you would if you were the issuer of a security under the issuer's exemption in certain private placements. But if you're a transmitter, that's when the full panoply of the regulatory regimen comes down on you, and you have to make sure you either comply with KYC and AML or you have an exception. There usually is. It is truly black and white when it comes down to those issues. So let's turn the page 6. Johanna, what happened in Cabbage Tech? So
in January, the CFTC charged 3 companies with fraud, and essentially the charges were quite similar for all 3 of the companies, that they had been operating fraudulently and had been operating Ponzi schemes. So in Cabbage Tech, this was probably the least creative of the 3 frauds. The defendants had set up a website, solicited customers to send them money, both fiat currency and also Bitcoin, and that in exchange they were going to give these customers advice on virtual currency trading, and they were also going to do purchasing of cryptocurrency and trading on behalf of their customers. Once they felt they had gotten enough money, they shut down their website, shut down their social media presence, and simply disappeared with the money. So that was probably the least creative. Entrepreneurs Headquarters Limited had a similar solicitation of Bitcoin from the public, but they promised to convert the Bitcoin into fiat currency, which would then be invested in a pooled investment vehicle that would be used to trade commodity interests on an online exchange that the CFTC had designated as a contract market. And the owner of Entrepreneurs Headquarters claimed he was very skilled in doing this kind of trading. He then posted fake results of the trading to the website, and when customers started investigating the results, he then faked a hack on his own website to shut his website down for several months and give him an excuse as to why he was not returning the customer's money. And then eventually, when that failed, he also closed down his website, removed his social media presence, and simply disappeared with the money. The final company that the CFTC charged with fraud, I think they perhaps found this the most entertaining of the three ones that they charged, because they mentioned it several times in their recent Senate hearing. The defendant solicited fiat currency and crypto by claiming that his product, My Bitcoin, was backed by gold, that he had a deal with MasterCard that would allow you to use My Bitcoin anywhere MasterCard was accepted, that it was trading on several exchanges, and he then proceeded to regularly, on a daily basis, post fake updates of the trading price of My Bitcoin that he literally just made up on his website. And so this enabled him to continue the fraud long enough to obtain $6 million, which he then proceeded to spend on real estate, antiques, and fine jewelry. So I think that the CFTC thought that this one was possibly the most outrageous of the three.
Yeah, but again, in all three of these cases, the common thread is faking information, misappropriation of funds, lying. I mean, these are pretty clear examples where the anti-fraud authority of the CFTC is appropriately deployed.
And these cases don't tell us all that much because at least from the facts we can see, they were frauds from the start. These weren't something where somebody tried in good faith to create something that went wrong along the way. These appear on their face to have been designed as frauds in the first place. And they don't really tell you what the regulators view in terms of what is and isn't permitted activity. We know intentional frauds are illegal.
Right. And that's a very important point. The probative value of these cases is, I guess, limited to their facts and the fact that they are, in fact, frauds. Or at least that's been the allegation in the enforcement actions. Do we know, have any of them been settled? I know they've been recently filed.
No.
No? Okay. So, in terms of what the CFTC is looking for, obviously, if they see a fraud, they're going to come after it. But we have other developments at the CFTC, and that includes that the CBOE and CFE started trading Bitcoin futures, and the CME as well. And that's a huge development and was viewed by many as what was a necessary first step to allow the creation of Bitcoin ETFs and others, because now you have a market price. Interesting idea, though, with an ETF. ETFs are either formed as so-called mutual funds or closed-end funds, rather, that have an exemptive order that allows them to trade intraday. But they are necessarily investment companies. As an investment companies, they have to invest in securities. Otherwise, you don't have an investment company. It's a definitional thing. So is a futures contract on a commodity a security? No. Bitcoin, we know, the CFTC has taken the position as a commodity. So a straight traditional ETF has a definitional problem. There are other ETFs, like gold ETFs, for example, that trade in the marketplace that are not securities ETFs and they don't even purport to be so-called 40 Act funds. Rather, they are generally publicly traded partnerships or trusts that exploit an exemption under the Internal Revenue Code for certain commodity-type pools, and that also are then traded and listed as securities, the interests of them, on the 33 Act, or under the 33 Act, rather. So they become effectively a securities trading vehicle that holds commodities. It's a very interesting animal that's out there. Even that structure, the SEC has been extremely unwilling to entertain because they feel that there's just not enough of a developed market. So the other options you have are something like a unit trust, where the asset is not managed, and the only thing that happens is when you get more money into the unit trust, you have to buy more Bitcoin. So in effect, that becomes an exchange-traded vehicle that holds Bitcoin. But it's not a managed vehicle. And the price just immediately reflects through to the owners of that entity. There is one currently outstanding. It's traded on the OTC or pink sheets. It is not an ETF per se because it's not a registered investment company, but it is, in common parlance, an ETF, and that is available on the OTC market.
That's been around for a while.
It has been around for a while. But, for whatever reason, it exists, right? And it's not considered a private fund because it's on the pink sheets.
The cash that a vehicle would hold to meet the margin requirements in the futures, that wouldn't help you meet the...
No.
Yeah.
No, generally not. So anyway, we have the Commissioner, Clayton and Giancarlo at CFTC and Clayton being very active in January and February. They wrote an op-ed in the Wall Street Journal on cryptocurrency and blockchain. And then in February, they spoke at a hearing held by the U.S. Senate Committee on Banking, Housing, and Urban Affairs. The CFTC has hosted back-to-back panels on cryptocurrency, blockchain, and their regulation. And they've created internal subcommittees devoted to cryptocurrencies and distributed ledger technology and finance. And one of the commissioners at the CFTC, Brian Quintez, encouraged the cryptocurrency industry to adapt self-regulating standards. There are consortiums of law firms and administrators and others in the space who have been trying to develop those standards, but it has been a very difficult row to hoe, as they say, simply because so many different competing interests have different ideas as to what is and is not an appropriate degree of regulation. And as in anything that's voluntary, the parties say, well, I don't like that particular regulation, I'm going to go elsewhere. And, of course, that makes it that much more difficult for a self-regulating standard to be applied. In terms of other CFTC developments, they seem to be, or at least the perception is, that they are more receptive toward token development than the SEC. Even though the CFTC has any fraud enforcement power, its reach into the crypto market is slightly more circumscribed. So, Todd, give us a general feel for what we're hearing from the CFTC. Again, the tone at the top seems to be a little bit different than what we would see at the SEC.
Well, I think it partly relates to the different regulatory schemes. If something's a security, right, looking at the SEC side for a second, then the SEC has a clear and existing regulatory scheme, which is either you sell it pursuant to an exemption or you register it, under normal.
Well, let's be careful here. When you say sell it, you mean the initial sale or the secondary market?
We issue with both.
Right. But that's a very important distinction.
Right. But there are, at least in theory, existing regulatory frameworks. The SEC has both for initial issuance and for resale and trading. The SEC can come and say, you're not fitting within the required regulatory framework, stop doing what you're doing. On the CFTC side, their regulatory framework historically focuses on futures and options on futures, focuses on designated contract markets like CBOT and CME, and it wasn't designed for somebody who's issuing a commodity, which is what Bitcoin is according to the CFTC, much the same way as the CFTC has certain regulatory power over foreign exchange trading. The CFTC doesn't tell England how to issue pounds or Europe on how to issue the euro, Japan how to issue yen. The regulatory scheme wasn't built that way. So when the CFTC sees Bitcoin or sees things like that are not securities or we think are not securities and that should be within the CFTC's regulatory purview, right now, unless you're engaged in fraud or you're doing a leverage transaction or something like that, if you're just doing spot trading and issuance, the CFTC has no clear regulatory authority or requirements, no registration requirements, no notice requirements, no nothing, unless you're engaged in fraud.
So, talking about the tone at the top of the CFTC, I'm looking at slide 8, the last quote there. We owe it to this new generation to respect their enthusiasm for virtual currencies with a thoughtful and balanced response and not a dismissive one. So that seems to be a very accommodating approach. And then, Giancarlo goes on further to say that appropriate federal oversight may include data reporting, capital requirements, cybersecurity standards, measures to prevent fraud and price manipulation, and anti-money laundering, and know your customer protections. Overall, a rationalized federal framework may be more effective and efficient in ensuring the integrity of the underlying market, which is a very I don't think anyone in this room or listening would disagree with any of these points.
I think the CFTC is trying to say, well, they do say they don't have direct regulatory authority over issuance, over spot trading, and they're trying to push Congress into giving them some statutory authority for a rational and reasonable way to regulate these things. And that's all they can really ask for, other than enforcing against on fraud type things. Because the SEC already has an existing regime that arguably covers this sorts of activity on their side of the table, the SEC has the ability to try to push people into that regime. The CFTC has no such regime to push you into. So at the moment, I think the CFTC, by definition, is going to look warmer and fuzzier because they can't push you into anything. There's nothing there. And so all they're doing is politely saying, this is very interesting, it's a very hot topic, there's lots of innovation here. Please either figure out how to SRO yourselves and or Congress, maybe you should come up with some sort of rational way to regulate that, and we hope everybody plays in the sandbox nicely. And that's how I view what they're saying.
Yeah, and for those who are not attuned, SRO means self-regulatory organization. FINRA, for example, is a self-regulatory organization that's authorized by the 1934 Exchange Act to regulate broker-dealers and exchanges.
I think what's going through my head, and I don't want people to, in my view, look at this the wrong way, I think because of the lack of a regulatory framework from the CFTC side, they have to appear friendlier because they have more limited tools to work with. I don't think on the enforcement side that may make them any friendlier than the SEC does.
Well, but again, history being a good informer here, when the CFTC saw issues in the nascent binary options trading market a few years ago, they had absolutely no problem finding jurisdiction and forcing people down the FCM route in order to become legitimate binary options trading.
And the LIBOR settlements recently,
exactly,
so hundreds of millions.
So there is that bully pulpit as well as the fairly big stick that the regulators do carry. I'd like to diverge for just 1 second. Recently, the Swiss got into the game with a white paper of their own, identifying what they view as 3 forms of cryptocurrency and trading. One is the so-called payment mechanism, which I guess you could refer to as like a Bitcoin type thing. Another is the so-called utility token, where the token gives you access to some service, function, or property that everyone would say is not tied to the efforts of others to develop a profit in a common enterprise. And then the third was an asset that's tied, a coin that's tied to something else, whether it's a revenue stream, appreciation in an asset, something that all of us looking at it would say, I know what that is, that's a security. So they have actually, publicly defined the 3 categories and said, as we would expect, whether a particular coin fits into A, B, or C is wholly dependent on the facts and circumstances.
I think we're not Swiss lawyers, we're just going off the 4 corners of the paper. But what's interesting about it, besides the fact they have this rather rational-looking way of dividing the world up, they also said, by the way, we're very concerned about AML and KYC in any of this, and we're also very concerned that regardless of which of these 3 things it is, when it could be an individual token or coin, could be a combo of all 3, existing Swiss security laws may very well apply. So one of the drumbeats that we hear a lot here in the U.S. is there are all these foreign offshore jurisdictions that are really easy to deal with and where there's no regulatory regime. And, in fact, from time to time, Switzerland's come up as one of those jurisdictions.
Yeah, that's just not true.
Right. Exactly. The Swiss are giving clear notice that we're going to regulate this stuff, particularly with respect to AML, KYC. We know it's out there. And it is what it is. And several months ago, there was a similar paper came out of France from the French market regulator that I think at that time they were a little bit less clearly forming their ideas than the Swiss are. The Swiss had the benefit of more time in the market, going back 3 months ago. But the French basically said, if you think you're doing an IC or a coin offering in France, we'd be happy to talk to you to give you our opinion in terms of what you're doing and how it fits under current French law and what you should worry about. So the regulators on a global basis are there, and I think my view is that the countries that are financial market centers, the Western Europe, the United States, Canada, generally speaking, while the details, it's like securities regulation. While there are differences in local regulation in terms of what's insider trading and what's required in the registration statement and how information goes out, most countries' security laws in general are fairly similar in their contours. And I think you're seeing that same sort of thing developing here. If the Swiss thing had come out from the SEC or the CFTC, it wouldn't have been shocking. It wouldn't have looked strange or weird from a U.S. perspective, I think. And I think that's an important lesson to draw, that many countries are going to regulate this, and the regulatory framework in many of these developed countries seems to be, to some extent, converging, at least at a high level.
Coalescing around A, B, and C.
Yeah.
And I think that's a very, very useful thing to keep in mind. The other thing to really keep in mind is that the extraterritorial application of the U.S. securities and commodity futures trading laws is extraordinarily broad. So, for example, if you are a U.S. person sitting in New York or Kansas or L.A., and you're brokering a trade with respect to a coin that was issued by a Dusseldorf, Germany issuer to a purchaser in South Africa on a Singapore exchange, you are still subject to the U.S. securities laws. You may have to be a registered broker-dealer, and if it's determined to be a commodity, you may have to be an associated person of a futures commission merchant or another introducing broker under the CFTC rules. Just because the activity is occurring outside, if you're involved, you have to worry about your own regulatory footprint and whether or not you're subject to these rules. Similarly, a U.S. issuer that sets up a subsidiary or an affiliate abroad to try to issue coin and avoid the U.S. tax laws, good luck. Since the 1960s, the Controlled Foreign Corporation rules, the inversion rules, and all of the other provisions of the Internal Revenue Code have been designed and implemented with the sole purpose of preventing what you're trying to do. So on the tax side, you very well may have income when you issue it, and certainly, again, from the securities side, unless you can fit under Regulation S, which is a very specific rule for purposes of foreign securities issuances, you have to worry about whether or not you've, issued a registered security.
I mean, also an interesting example.
Or registration required security, excuse me.
An interesting example I came across recently was an ICO issuer that was formed in the British Virgin Islands, where all the offering was purportedly being conducted under Estonian law. Although if you read through the documentation, it looked very New York and U.S. law written in terms of somebody simply, I think, taking a U.S. law form and switch it to Estonian. So my guess is it didn't even match Estonian law, whatever Estonian law is, and then purported that exclusive jurisdiction for any disputes, litigations, or regulatory affairs was Singapore. Okay, so you're gonna go for British Virgin Island issuer, BVI issuer, into a Singapore court who's going to try to apply Estonian law. Yeah. Okay, so I don't know what will actually happen, when things go wrong on this.
Yeah,
but my
New York law applies.
Exactly. So we see people try to do things that I would describe as cute.
Yeah.
That I don't think will really do you any good, and frankly might have all kinds of bizarre unintended consequences, because maybe it turns out the court will apply Estonian law, and you just discovered that under Estonian law they will not respect the BVI issuer, and you just became personally liable, or some other strange things will happen because you lured it yourself.
Right.
And,
Well, and it's like people who use Dr. Google to diagnose their, ailment in their own personal health. You don't use Dr. Google to, draft legal documents, and if you do so at your peril.
Or to search on yourself.
There we go. Joe, we hear a lot about people, talking about Bitcoin, blockchain, and they invariably confuse the two. Mm-hmm. So from a tech perspective and a legal perspective, what is blockchain?
So the blockchain technology is really what enables Bitcoin, right? So they're certainly not synonymous, but Bitcoin happens to be the first implementation of blockchain technology, and arguably it's one of the most successful, if not the most successful, in terms of adoption. But basically, it is I guess the easiest way to think of it in very simplistic terms is it's a read-only database, right? And where transactions are not written to the database until everybody that is monitoring the network that has access to the blockchain database has agreed that is legitimate transaction.
Okay, well, all right. This is something that's always puzzled me. How do you become one of those verifiers? You just put up your hand and say, "I'm a verifier"?
Yeah. So it's basically a database it's decentralized and it's available to anybody. So you and I can actually download our own copy of the Bitcoin database. But there are miners, so-called nodes, all around the world. Happen to be very concentrated in China right now, but they are basically working to solve a very complicated math problem to verify these transactions. But you can basically set up mining rigs to mine these transactions, and it's a computational race. Whoever figures out this sort of verifies the transaction first, and the network agrees, actually gets paid or compensated in Bitcoin.
That's how you declare yourself the winner. The nodes are basically self-declared by I invested money to buy a very high-speed computer or network of computers. I put the appropriate software on there, and I solved the problem first.
And I paid the power.
Right. Yeah, but that has absolutely no relevance to Giancarlo's example of a blockchain transaction where soybeans were sold by Dreyfus Company to China. Okay?
No.
Who are the verifiers there? How does that work? I mean, take it out of the context of Bitcoin. Let's focus on specifically, using distributed ledger technology for, simple verified tasks. Do I have a private blockchain? Do I identify who the nodes are, what the rules of the smart contract are? How does it work?
Yeah, so if you think about just a basic, sort of take a step back and basically a fiat currency transfer, right? If I were to take a dollar bill and hand it to you, I don't need anybody else to verify that transaction happened, right? So if you take that and you convert it into a digital world, right, it becomes a little more difficult because I can make a copy of that digital dollar or whatever it is, and I can distribute it to multiple people. And so the way the banking industry has handled that is, we create a ledger, right, and we'll keep track of it, and we, the bank, or we, the central authority, will track it for you. And so that works, except that you've got centralization, the central authority, and it's worked fine for 100+ years or so. But how do you do that in a decentralized manner? The way you do that is you basically take a copy of the ledger and you give it to everybody in the network, however you define the network. You give everybody a copy of this.
So there has to be, the Wizard of Oz. There has to be somebody who defines the network and the parameters and who can be the holders of the ledger.
That's right. The rules are built, actually written into, not in the case of Bitcoin, but the protocol is actually written into the database itself, right? And so basically transactions do not occur on the network until everybody in the network, however you define the network, has verified and agreed that those transactions are legitimate. To your point about sort of what can we do with this now, is so you can imagine a world where we are able to verify this digital currency, this virtual currency that never existed before, without a central authority. If you strip away Bitcoin and you start looking at this technology and say, wow, we can tokenize physical assets now. We can tokenize virtually any asset like a unit of energy, track it in a decentralized way, and you can start to imagine all kinds of ways to track whatever it is with tokens, physical commodities, and digital currencies and new assets altogether without having a central authority to have to verify and watch over transactions and transfers.
Now, when you say tokens, you're not talking about actually minting a coin. You're talking about some form of digital password, cryptological...
Right. Some sort of token, whatever, then that's what the 1,500 or so of these altcoins and cryptocurrencies that are trading on these, they represent a digital, it's a digital representation of something, whether it's a new asset that's trading on these blockchains or a physical asset like gold or some traditional commodity. It's represented digitally on these networks.
So let's say you take a state and, the Secretary of State of that particular state has various functions, including tracking corporations. If there's a merger or transaction, the company needs to know who the shareholders are. Theoretically, a state could set itself up as the verifier of that state organization, that state blockchain for the corporate records of any entity that's incorporated in that particular state.
Right. And you're explaining what Delaware has done and what Wyoming's trying to do, and so yes, they are. That is a great use case for tracking traditional shares on a blockchain. So the shares still exist, but they're represented digitally with the token that's settled and traded on the blockchain.
Yeah, and if you think about any tech company, invariably in order to raise capital to develop the idea and then develop a usable product and take it to market, these companies need money, and traditionally they don't have the resources, or they really don't know what they don't know, to track corporate ownership. Yeah. And so when they go to an IPO, for example, there's always a mad scramble to clean up the corporate charter.
Yeah.
And you have to squeeze out mergers and other things in order first to start with a clean baseline, and then you take the clean baseline to market. Yeah. If all share issuances are on the smart contract, now who would be the verifier there? Is it the state? Do they take that responsibility, or is it the company and perhaps an administrator like Trident Trust?
Yeah, so there's the fully distributed, decentralized, where all the nodes could be the verifiers. But you can have a completely private blockchain as well, where the verifiers are a subset of banks. You can have a semi-private block. So it depends. Your consensus algorithm method can vary. You can set it up however however it fits your use case.
I think to go to your question, Greg, I think in the case of a corporate, I think that they're going to have to need somebody like a transfer agent or some third party who verifies the initial creation. Transfers you might be able to allow in some sort of distributed way, but a company, you can't have people creating shares out of nothingness, right? There ultimately has to be some check on initial share creation, right?
Well, normally that's done when you file articles of incorporation that list that the company will have 1 million shares of Class A shares. So the company creates the shares with the complicity of the Secretary of State.
Well, I want to raise one point. You're raising a very important point as to why this is so challenging for lawyers and the bar and regulators, and that is we just talked about these tokens, which could represent a unit of energy, it could represent some new type of currency, and now you just talked about it representing a share. So you've got these tokens that can represent anything in the world, virtually anything in the world, but yet they can take different forms. In the example you just gave, you've got a token that represents a share. I don't think anybody would argue that that's not a security. But what happens when you've got a token that's linked to grain or a true commodity, right? Or it's a real currency like Bitcoin
or carbon credits.
Or carbon credits. So if you look at sort of the categories that the Swiss regulators just proposed, a payment token, a utility token, and a so-called value token, isn't it really just currency, commodity, security? I think they can represent more of these things.
I think they chose not to do that because one of their other comments was a token could have characteristics of all three.
That's right.
And by the way, please don't forget the fact that we have security laws in this country.
That's absolutely. It could, and depending on who's holding it, there are some people that may hold it for investment purposes. There are others that may hold it for true utility purposes.
I think they were trying to thread a difficult needle, which is they wanted to provide some sort of framework for people, at the same time not open some giant hole where, by the way, if you fit into this category of security law and our AML law doesn't apply, and they were careful to say, no, that's not what we meant.
Yeah. All right, so let's take this back to where we are right now in the marketplace. If you look at slide 11, you'll see that from the end of 2016 to the end of 2017, there was a meteoric rise in the number of so-called ICOs, initial coin offerings. These coin offerings take the form of either so-called utility tokens, hybrid tokens, or securities tokens. And we've had the statement by the SEC that effectively says, we think that a lot of these so-called utility tokens look more like securities and therefore should have either a registration or an exception from registration under the 33 Act. And before they trade, they better be traded by a broker-dealer who's running an ATS, and that provides all the protections to investors, whether those are accredited investors with a limited secondary market or pink sheet trading after a year. I mean, this is a very, very big cliff. Because if you're wrong, if you purport to issue a utility token and you're wrong, you have all this retroactive risk, including the likelihood of rescission, because that is the remedy under Section 29B of the 34 Act, which is rescission.
Give me my money back.
Not give me the current value. Give me my money back, which means that the issuer is probably at this point bankrupt. So Dave, you're on the front lines of this, right? You're an administrator. You're dealing with people who are setting up funds or issuing ICOs. How do you draw these lines and make sure that everybody gets the benefit of their bargain?
That's right. Well, going back to your previous slide, it's amazing to see just all that investment into these ICOs lately. And our managers, we've seen a huge, very heavily into them. So they've actually been sort of veering off of their original PPM. And it's those conversations that we've had to have with the managers, with the law firm saying, hey, guys, you're only supposed to be 20% in ICOs. You're 60. So I think people are getting excited about them, and again, it boils back to I think, returns, what they're chasing. How do we account for them? Side pockets, I think, is everyone aware?
Yep.
That's how these illiquid investments are.
Now, are you setting the side pockets up as special allocations under the tax rules, or are you actually creating separate series which ring fence and red circle the asset?
Yes, that's how we're...
You're actually creating separate series for the ICOs.
Yes, that's how that's done. Other things that just are very important is the valuation of these side pockets. That's something that we say has to be well thought out with the managers and the audit firm. That's the type of thing where, the SEC is going to scrutinize big time about how, for example, performance and management fees are collected on those ICOs. So from our perspective, those are conversations that we have with audit and with managers.
Well, you have things like Bitcoins or Ether that have a thicker, deeper market. Are those things side pocketed as well, generally?
No. Typically, those are part of, most managers will create, for example, an S&P of the top 20 kind of coins out there, and then they might have a small percentage that'll do day trading and a smaller percentage that's ICOs. But as I'm saying, as of late, that ICO percentage has been rising.
Now, are the managers going through the looking glass and saying that these coins are securities, or they're treating it like Schrodinger's cat? We don't know whether it is or isn't, but we're just going to assume it is? What are they doing?
I think they're viewing them as securities. Honestly, a lot of these managers are just simply looking for the returns.
Irrespective of whether or not the issuer thinks they're a security.
Right. The other thing, and I'll mention that I don't have, is we've been seeing a lot lately actual tokenized funds approaching us. And they've come to us with Singapore entities issuing the tokens and then literally creating a tokenized fund. From our perspective, Todd, you mentioned the AML KYC. We've treaded lightly, and as of yet, we've not taken one on board just because we have such concerns with the AML KYC and who is doing that.
So take a step back and just focus on the fund that holds the coins. So what you're saying is you're embracing regulation. You're saying that they are, in fact, you're going to treat them as if they're investment contracts and securities, even if the issuer is jumping up and down saying, no, this is a utility token.
Yeah.
And as a result, you're making sure that the fund sells to accredited investors or, has another exception available, right?
Yes.
And the managers are registering as registered investment advisors if they're over the $150 million limit?
They are, yes.
So they are paying homage to the regulatory requirements. And there really is nothing being missed here. It's just like any other asset class, which from the point of view of the regulator, those who are listening on the line, should be very comforting because, the industry is actually doing what it's supposed to do, which is call a spade a spade,
right,
say it's a security, and treat it as such within the structure of the fund.
Two other observations. The AML point, the AML rules generally were not written to think about tokens or these sorts of things, and so it isn't always clear whether all these activities fit neatly into an existing statutory, classification. Regardless of that, as a practical matter, people, we think, should be applying AML, KYC, these sorts of activities.
Well, again, be careful. There are proposals to make funds and advisors AML initial reporters. They are not finalized rules.
No, I'm thinking not so much on the fund side, but more people who are issuing.
Well, issuers is a different story, but again, if, go back from a policy point of view, if an issuer issues a token and there is no way for the purchaser of the token to cash it in or spend it on something else, and it truly is an investment, the likelihood of there being an AML risk is very, very low.
Exchangeable?
Well, is it exchangeable? If these are securities that have been issued with appropriate 33 Act limitations, it's not going to be exchangeable for a year without the involvement of, so it is almost like not a bearer instrument, a registered instrument. So you got to be really careful about, extending the AML rules. They are very broad and the panoply is very rich. However, in terms of what you need to do as a fund, At a minimum, you need to know who your customer is. You need to verify their status as an accredited investor. And if you're taking a performance fee and treating it as a security, you got qualified clients, right? Got to worry about state blue sky like you normally would. And you have to KYC. But in terms, and if you're providing a ready market and allowing people to move in and out of your fund without limitation, you got an AML.
I think both Dave and I were thinking more in that context.
Right.
That's what we're thinking.
Yeah. But if you're running a traditional, legitimate investment fund, the AML concern is probably a little bit higher than that.
I think from Dave's perspective, what he's worried about is somebody coming to him with a fund located in Singapore, which is, instead of issuing normal interest as you see it,
is issuing
tokens, which is trade who knows how, and he has no easy way. Right, he doesn't know.
Who knows? And that fund you probably should keep at an arm's length.
Right, and what goes through my head is whether or not that fits neat with an existing AML KYC regs. It might be a good idea to assume it should.
Yeah, and that again is one of those where you have to tread lightly. Exactly. So in our last remaining moments, wanted to do a quick update on some other developments. Johanna, what happened in PlexCoin? That was the SEC cyber unit filed charges against Dominic LaCroix. Okay. Well, in PlexCoin, we had, again, the SEC going after someone who was a known fraudster, had been, I believe it was Canada, had also gone after LaCroix, and they stated it was a scam. So again, known fraud, and we do what we do when we see a known fraud. Clayton has said calling it a utility or structuring it to provide some utility does not prevent the token from being a security. Again, a word to the wise. Got to be very careful. The label is almost irrelevant. Yes.
I would note in PlexCoin it's an interesting case because the accused is very vigorously disputing the government's case in every way, shape, and form. It'll be interesting to see how that ultimately works out, whether they're successful with their defense or not.
Todd, what happened in Munchie?
Munchie, basically, somebody was trying to do an ICO. They were basically in a pre-sale type phase, and they thought there was a utility token, and from their point of view, and they received I don't know if off-the-record way to put it is the right way, but a call from the SEC saying, we've seen your materials, we're aware of you, and we disagree with your analysis. We don't think you're a utility token. We believe, in fact, you are proposing to conduct unregistered securities offering without the benefit of an exemption, so we suggest that you voluntarily cease and desist from your activities, which is apparently what Munchie did.
Yeah, but there were two major issues. The investors could expect a return, and there was intended trading on a secondary market. And again, you cannot trade an unregistered security on a secondary market unless an exception like 4A7 under the 33 Act is available and the information is available to make that happen. Or you go to something that's a 1 year or longer vintage on the market, and you're trading on the Think Sheet.
That's one of the difficulties that are faced by a lot of ICO issuers, not just in the U.S., but also on a global basis, is how do they have an effective secondary market that works while complying with whatever securities and other regulations exist in various countries, potentially.
Munchie was an interesting case. I think it shocked the legal community in the sense that a lot of lawyers would have argued that it was basically a token reward system for the restaurant business, and some lawyers would have argued that was a utility token or it wasn't a security. It was just a matter of sale. The SEC didn't talk about matter of sale. The matter of sale was relevant because they did tout it as an investment opportunity and did talk about secondary market trading. What we don't know, and this is a big open question, is if those facts were removed, the promoting as a great investment opportunity in secondary market trading, would the SEC have come to a different conclusion? We don't know the answer to that.
And this was an unofficial conclusion. We weren't on that phone call.
Right.
We don't know what the SEC said.
Right.
We don't know what the risk tolerance was of the promoter for the ICO, and it's an example of the SEC essentially making law through unofficial, very unofficial. People always criticize the SEC and other regulators making law through enforcement.
But it's a lot easier if you're a regulator to make law through enforcement than it is to go through the Administrative Procedure Act and what's required to get a regulation passed in this administration.
No, I agree, but in an enforcement action, at least you get to see some 20-page document the SEC releases where we are enforcing the following laws for the following reasons, blankety blank, and they actually give you some facts. They tie to the law.
But not in a voluntary cease and desist.
Right, here you have a phone call, so you have no idea what actually happened.
Right. So, and real quick, Arise Bank?
So Arise Bank was, a scam to end all scams in some sense, because what they did was rather bold, where they claimed they raised $600 million in basically an ICO bank, for lack of a better word, and they didn't raise anything even close to $600 million. But what's even more amusing was they claimed that they'd actually purchased a real bank, an actual existing bank in the state of Texas. And they gave a name for that bank, and nobody could find that bank in existence anywhere. So first, the Texas state regulators went after them. Basically, they claimed they bought the Texas bank, and that was apparently fraud. And then, they quickly followed by federal enforcement action. So I think, again, it's an interesting case, and that somebody is very bold, but their activity was outright blatantly fraudulent. And I think it takes a great deal of, is courage the right word, to have an ICO where you fraudulently claim you bought a non-existent bank. I mean, that's fraud at its most, basic level.
So, in the Senate hearing, Commissioner Clayton said that a note for professionals in these markets, those who engage in semantic gymnastics and elaborate structuring exercises are squarely in the crosshairs of our enforcement division. Translated, that means lawyers, accountants, administrators, valuation experts, structuring consultants. You got to call it what it is and let the regulatory consequences fall where they may, and it may mean that you cannot do what you want to do in terms of certain utility token freedom.
And one of the struggles that we face is that all the public enforcement actions are clear and obvious. They're fraudsters. They lied. They cheated. They pocketed the proceeds. They bought themselves nice jewelry. The bank never existed. They never intended for it to exist. We don't yet have any real cases out there where somebody honestly tried to do something in a fair way, and then the regulator disagreed with their analysis.
We do have the Dow. They honestly tried to do something in a fair way, and unfortunately, the regulator said, no, that is an organization, unincorporated.
Right, but the Dow is really more an after-the-fact dissection. There's no litigation there, and the Dow has a lot of facts in it, which are unlikely, I think, to repeat themselves as to what the sorts of things they were doing. It was a very interesting thing. We wrote a very interesting paper on that, actually, as I recall.
So our last quick shot across the bow, again, tax. You can't forget about the tax man. It is likely that the proceeds of an ICO are taxable income by the entity that receives them. Think about that. That means under current tax laws, 21% for a C corporation is immediately going to the federal government from the proceeds of the ICO. Most states follow federal, so that means if you are in a state that has a state income tax, you're going to have anywhere from 3 to 10% go off the top. And if you're selling software, you very well may have a sales tax. And so you're looking at anywhere from 30 to 45% of the proceeds going poof on day one, because you wanted to structure a utility token. On the other hand, if you sell a security, there are tax rules that say when a company sells a security, the proceeds are not subject to tax. And it has to be the right type of security. It has to either be equity or debt. So, if there ever was an incentive to embrace regulation and follow the securities rules, there's one. You save 35 to 45% of your proceeds because you decided to call it a security, and you make it have equity flavor, and you therefore take the proceeds in on a tax-free basis.
You're making a very interesting point, not just in tax, but if I was a business person. So I'm trying to raise $200 million in my ICO, say, and I'm trying to save $10 or $15 million on legal bills and securities compliance and underwriting and everything else.
And I'm going to spend 80.
Even ignoring the tax, the question is, if you really can raise $200 million, why wouldn't you want to raise $200 million in some way that is well understood and known?
Exactly.
Where you know what the regulatory framework is, you know how to deal with it, as opposed to this other thing where you have no idea what's really going to happen, and the like. And while we're not business people, it's an interesting conversation that you have to think about. What are the costs, direct and indirect, of the approach you want to take, and what's going to be more effective for you? I mean, ICOs and Bitcoins and blockchains, all very, very interesting, and there are ways to do ICOs, as a securities offering. They certainly can be done that way.
Absolutely.
And I think people should think carefully about, the expenses and costs and difficulties of different routes, and think about what really makes sense, as opposed to, just reaching for the first thing that walks by because it looks easier.
Yeah, well, it usually isn't easier, especially when you're dealing with other people's money. Thank you to my panelists for joining me this afternoon, and thank you for our audience for attending. We'll see you next month. Have a great day.